and the issue of women with disabilities in conjunction with the CRPD. The next slide, please. As a quick outline, I will be focusing on general comments of the committee, and particularly the general comment number 3 from 2016. The other two general comments, the general comment number 6, you have already heard about this morning, but also I will be bringing into the discussion the CEDAW committee's general comment number 35, which is an update on their earlier general comment on violence against women. And view of the concepts I will be discussing are intersectionality, vulnerability, empowerment, and transformative or inclusive justice. The issue of violence against women with disabilities is a pervasive and a very important theme, and I will be focusing on the ways to prevent that, to have more effective victim support, and to improve access to justice for victims. Next slide, please. And this is your afternoon exercise. I have only the numbers of the articles, so we can all remind ourselves what the themes are on those articles. But to make it easier, I will tell you that the core articles already mentioned by colleagues, the 4.3, the 5.2, are also relevant for women and children with disabilities. But the specialist articles number 6 on women with children and number 6 on women with disabilities and number 7 on children with disabilities are specific articles in recognition of the need to link CRPD to earlier conventions, the Convention on the Rights of the Child and the CEDAW Convention. And the issues of family life, freedom from violence, and also rehabilitation. These are all important issues, but the privacy and family life are one of the articles that specifically relate to women and children with disabilities. There will be a specific presentation on children afterwards, so I will be focusing on women as I promised. The general comment, next slide. The general comment number 3 from 2016 referred to strong evidence to affirm that women and girls with disabilities face barriers in most areas of life, and these barriers create situations of multiple and intersecting form of discrimination against them. Next slide. Particularly with regard to equal access to education, access to economic opportunities, access to social interaction, and crucially, access to justice and equal recognition before the law. The ability to participate politically, and on this point I'm very proud to tell you that Finland in the very recent election overcame Sweden as the country where we have most women in the parliament. Sadly, we don't have any disabled MPs, but we have the most women in parliament in the EU. And that's one way of looking progress in terms of political participation. And the control over our own lives is important. The Article 19, living independently in the community, is very important. So, next slide. So, there's a lot of focus on state obligations, but I see it also as an intrinsic part of the prohibition of discrimination. And this should be applied in conformity with CRPD and no reservations allowed. A key issue that I would like to raise are the barriers caused by disbelief when persons are reporting sexual violence, and also the need for further training of professionals in justice sector. These remain key challenges moving forward. Next slide. And I would really like to take a moment to discuss the multiple and intersectional forms of discrimination. Multiple discrimination encompasses situations where a person can experience discrimination on two or more grounds, whereas intersectional discrimination refers to situations where several prohibited grounds are in operation and that they interact in a way that it's very difficult to separate which part of this situation is, for example, gender discrimination and which part is discrimination on the ground of disability. So it's a bit like eggs and omelette. If you break the eggs and make an omelette, it's very difficult to bring the eggs back again. And that's one of the paradoxes of the discrimination law we have currently in many countries, that you're expected to bring a case differently or separately, first on the issue of disability discrimination, and then separately, for example, if it's an issue of gender discrimination in terms of employment or wages. And next slide, please. And it's very interesting to see that the concept of intersectionality has started to gain recognition as a concept in law by European courts and human rights operators, particularly the courts. And this has a very key relation to stereotyping, which the general comment number 3 reflects on and says that gender stereotypes can limit capacity to develop women's own abilities or pursue careers and make the choices about their lives and life plans. So stereotypes can be harmful even if they are seemingly benign. And these harmful gender stereotypes need to be recognized and addressed so that we can progress towards greater gender equality. The goal of promoting gender equality is key here. In terms of the formal equality, how to combat direct discrimination by treating persons in a similar situation similarly and peoples in a different situation differently. That's one way to combat negative stereotyping and prejudices, but it falls short because it cannot offer solutions for the dilemma of difference. And this whole agenda of substantive, affirmative, and transformative equality is interesting in that they seek to address structural and indirect discrimination, which are most pervasive and difficult to account for, difficult to perceive even if you're not recognizing the existing imbalances. So we need to take into account power relations. And this dilemma of difference, it requires both ignoring and acknowledging differences among human beings so that we can finally achieve de facto equality. And the convention is based on this new model of equality, transformative or inclusive equality. And it's reflected also in the general comment number 6 that we've already discussed. And that it's important to acknowledge that individuals on a general basis, we experience discriminations or we belong to several social groups. We have multifaceted identities, and that these groups and these identities are not always homogeneous. And this is a new model of equality, and I think it's developed throughout the Disability Convention. It embraces a substantive model of equality, and it extends and elaborates the way we see equality, or what the content of equality is perceived to be, particularly in that it recognizes the dimension to combat stigma, to combat stereotyping, prejudice, and violence, and bring about a more fuller recognition of the dignity of human beings, and that they are multifaceted and live in intersectional situations. So this transformative equality leads to real change. It means that we need to change dominant rules, rules that reaffirm exclusions, and that we need to go beyond the traditional dichotomy of equal different. So what solutions can we find? And so the non-discrimination, sorry, next slide. Next slide. I left you behind, sorry for that. Next one. That one, yes. So, so we need to think of discrimination law not only targeting and supporting and protecting individuals, but also groups. And the CRPD is the first human rights treaty to acknowledge explicitly that intersectional discrimination exists. And we are seeing some first moves towards this change, so that European case law, ECJ, is slowly and in rather hesitant steps following this change. So the CRPD is not only an independent normative structure, but also interpretative framework for national judges. And this is the important thing. It was mentioned earlier today that it's an indirect interpretative guideline that the courts are turning to the CRPD to have some kind of reference point in the decisions. So this interpretative framework and making it more known and making it more like customary to use it or to turn to it in cases of disability discrimination is very important. And also to raise somehow. It seems odd, we fought so long for the CRPD and we thought that that was the nec plus ultra, nothing higher. But now we see after 10 years of implementation that we really need to work on making it the interpretative framework. And there's a lot of work to do on that. And I think, and I would like to thank ERA for the contribution you have made in creating this course and working together with EDF and other organizations to bring a little bit that change about. So, next. Now I'm turning to new territory, let's say, the CEDAW Committee General Comment 35, which is actually an update of their earlier jurisprudence. And I think it's very important in this regard because it restates and reiterates that discrimination against women, which is prohibited in Article 1 of CEDAW, includes gender-based violence. And this is violence directed against a woman because she is a woman, or that it affects women disproportionately, and as such is a violation of their human rights and human dignity. So this goes beyond non-discrimination exclusively towards empowerment of women. It becomes an interpretation tool. Next slide. So I'm also referring to the report of the Special Rapporteur on the rights of persons with disabilities on sexual and reproductive health and rights of girls and young women with disabilities. Next slide. And we've already mentioned that the risk is higher. How much higher and how you measure it is perhaps a matter of some contention around the world, but I think we can agree that children with disabilities are almost many times, and the rapporteur says almost 4 times more likely to experience violence than children without disabilities. And that this risk is consistently higher in the case of girls who are deaf, blind, and autistic, or who have psychosocial or intellectual disabilities or multiple impairments. Next. So these challenges remain. And one of the key challenges in statistics and in creating new policy action is that sexual assault is so often underreported, and it's even more so in cases of women with disabilities. So, as survivors of sexual violence, they report the abuse or seek assistance or protection from judicial and law enforcement officials. Then often their testimony, especially that of girls and women with intellectual disabilities, is too often generally not considered credible. And that creates a quandary because if the testimonies are not, if the stories are not considered credible, they are disregarded as competent witnesses, which leads to perpetrators avoiding prosecution. Next, please. And these barriers to the justice system, I think, are one of the key elements that we would need to work on together to change, so that the physical and communication barriers that exist in the justice system, that create in themselves barriers hindering access to justice for girls and young women with disabilities, so that they have a limited ability to seek and obtain redress. So this lack of accessibility, unreasonable and procedural accommodations, such as sign language, interpretation, alternative forms of communication. I'm thinking of bliss symbols, for example, for persons with intellectual or communication disabilities. And these support services that should be age and gender sensitive. This combination of being age and gender sensitive seems to be really the crux of the problem. Next slide, please. Stereotypes and prejudices. And this leads to discounting the testimonies in cases, because too often there's a questioning whether girls and young women with intellectual disabilities can understand the oath, what testifying means. And it can lead even to discrediting the testimony of blind witnesses, because they are not, quotation marks, able to know or perceive the sequence of events. Next slide. And another issue that I would like to raise, which has also implications, particularly for young girls and women, is the family planning and birth control issue. Next. In relation to respect for dignity, agency, legal capacity, there's a very key issue of forced contraception and sterilization, which can result in sexual violence. EDF has been active in bringing this issue to the fore in the European Parliament and has provided many testimonials on this issue, but it remains contentious. And it's important to note also that violations of sexual and reproductive rights may amount to torture or inhumane treatment. And in this regard, as in many others, but particularly talking about these sensitive issues, it's very important to raise the paradigm of supported decision-making and the right to be assisted and having assistance while making choices regarding the exercise of sexual and reproductive health and rights. Very, very concretely, are you able to have assistance to raise children? Next. The committee also made recommendations, and these recommendations, I think, are very relevant to the issue at hand, and it again brings out the need to repeal discriminatory laws, policies, and practices that prevent women with disabilities from enjoying all the rights of the CRPD, and to adopt appropriate laws, policies, and actions to ensure that the rights of women and women with disabilities are included in all policies, so that law becomes not gender blind, but gender sensitive. Next slide, please. And it's very important that we remove all the barriers that prevent and restrict the participation of women with disabilities, and ensure that women with disabilities through their representative organizations are included in the design, implementation, and monitoring of all programs which have impact on their lives. So this inclusion is one of the key recommendations. Next slide, please. What does then policy making with a gender perspective mean? How do we do awareness raising and training of professionals? On these issues, I would like to turn your attention to a couple of good practice examples that we have had in some of the member states. Myself, I was involved in an effort that was made not under the CRPD, but under the GREVIO, the European Council Convention on the prevention of family violence and near partner violence. And under that framework, there was an effort to bring out this very taboo subject of sexual abuse and violence towards disabled women, particularly in institutions. And we were thinking, what can we do to bring out this issue? So we worked together with the National Institution of Welfare and Health to produce a reference book, a guidebook to professionals in the field that included writings both from experts in the subject theme of violence, but also, how would I call them, lived experience testimonials. So all themes were looked at from two sides. And that was very effective in the sense that it gave two perspectives into this very sensitive and very silent subject. And we were very, very glad of that experience, working together with experts to try and bring out the taboo, break the silence around it. And also we managed, which I'm very glad to say, it's not often that you manage to get organizations of persons with disabilities also to bring out these very taboo subjects in their work, in their local work, having discussion groups and working methods to bring out these issues and discuss about them and have language to talk about them. And for that, I would, out of a personal and also lived experience, I would tell that these kind of cooperations between national officials who are tasked to do awareness raising and disability NGOs is very important. And I think what we need to do in the awareness raising and training is to have a mix of perspectives. The issue of accessibility, for example, shelters for women. In my country, Finland has had many, many times recommendations, conclusions from international human rights bodies about the lack of shelter places compared to the pervasiveness of violence against women and close partnership violence. But within that problem of lack of support services, lack of shelters, is an even larger problem that among those shelters that were already regarded as very, very few in number, there were very limited numbers that were actually accessible for people with disabilities. And I'm talking not only of physical access, but also access in terms of information, that you wouldn't even know whether the places were accessible. The issue of emergency numbers has also already been raised, and that's also a problem in my country, that if you are a deaf person, it's very, very difficult to phone 112, because for text messages you need to know which region you're in. You need to be registered as a deaf person to use that specific service with a specific number in this area of the country that you have to know, like a silent information. It's not given publicly because risk of abuse, they say. And also the whole idea of reasonable accommodation. In many of even the shelters that were regarded accessible, suddenly when we asked whether we have accessibility audits of these places, there had not been any audits. it was presumed that they were accessible without any testing. We are still waiting for a comprehensive review, and that's one of the points that I would like to highlight to our colleagues in different countries, that if you're debating with officials about the need of having accessible shelters, ask how many there are. I would not be surprised if nobody knew. And that's something we need to change. And this whole issue of access to justice, as lawyers, we are very keen to have access to justice because that's where the remedy starts. But it would also need procedural accommodations, particularly for vulnerable populations. And the whole issue of effective remedies, it's true that justice can only prevail if there are remedies. And for sexual violence and abuse, particularly in institutions, it's a very sensitive subject and very difficult to bring into a successful or even tolerable result for the victims, because when the trust is broken, as it is in a violence issue, it's very difficult to build that trust again. So that is something I would very much like to see, is more research on the issue of effective remedies and support for the victims. Thank you kindly for your time and attention, and if you have any questions, I'm happy to answer them. Thank you.